The monarchy of Canada is at the very core of both Canada's federal structure and Westminster style of parliamentary and constitutional democracy. The monarchy is the foundation of the executive, legislature, and judiciary in the federal and each provincial jurisdiction. The Canadian sovereign is the personification of the Canadian state and, as a matter of constitutional law, is Canada. The current Canadian monarch, since the 6th of February 1952, is Queen Elizabeth II. Royal succession is determined according to common and statute law, which stipulates the throne is inherited by the sovereign's eldest living, non-Catholic child or, in the case of a childless sovereign, the nearest collateral line. As such, Elizabeth's son, Prince Charles, is heir apparent, although the person of the sovereign is equally shared with 15 other independent countries within the Commonwealth of Nations. Each country's monarchy is separate and legally distinct. As a result, the current monarch is officially titled Queen of Canada and, in this capacity, she, her consort, and other members of the Canadian royal family undertake public and private functions domestically and abroad as representatives of Canada. However, the Queen is the only member of the royal family with any constitutional role, while some powers are exercisable only by the sovereign. Most of the monarch's operational and ceremonial duties are exercised by his or her representative, the Governor-General of Canada. In each of Canada's provinces, the monarch is represented by a lieutenant governor. As the territories are not sovereign, they do not have a viceroy. As all executive authority is vested in the sovereign, their assent is required to allow for bills to become law and for letters patent and orders in council to have legal effect. While the power for these acts stems from the Canadian people through the constitutional conventions of democracy, executive authority remains vested in the Crown and is only entrusted by the sovereign to the government on behalf of the people, underlining the Crown's role in safeguarding the rights, freedoms, and democratic system of government of Canadians, and reinforcing the fact that governments are the servants of the people and not the reverse. Thus, within a constitutional monarchy, the sovereign's direct participation in any of these areas of governance is limited, with the sovereign normally exercising executive authority only on the advice of the Executive Committee of the Queen's Privy Council for Canada, with the sovereign's legislative and judicial responsibilities largely carried out through parliamentarians as well as judges and justices of the peace. The Crown today primarily functions as a guarantor of continuous and stable governance and a non-partisan safeguard against abuse of power. The sovereign acting as a custodian of the Crown's democratic powers and a representation of the power of the people above government and political parties. Canada is one of the oldest continuing monarchies in the world. Initially established in the 16th century, monarchy in Canada has evolved through a continuous succession of French and British sovereigns into the independently Canadian sovereigns of today, whose institution is sometimes colloquially referred to as the Maple Crown. International and domestic aspects. The person who is the Canadian sovereign is equally shared with 15 other monarchies in the 53-member Commonwealth of Nations, with the monarch residing predominantly in the oldest and most populous realm, the United Kingdom, and viceroys acting as the sovereign's representatives in Canada. The emergence of this arrangement paralleled the fruition of Canadian nationalism following the end of the First World War and culminated in the passage of the Statute of Westminster in 1931. Since then, the pan-national crown has had both a shared and a separate character, and the sovereign's role as monarch of Canada has been distinct to his or her position as monarch of any other realm, including the United Kingdom. Only Canadian federal ministers of the Crown may advise the sovereign on all matters of the Canadian state, of which the sovereign, when not in Canada, is kept abreast by weekly communications with the federal viceroy. The monarchy thus ceased to be an exclusively British institution and in Canada became a Canadian or domesticated establishment, though it is still often denoted as British in both legal and common language for reasons historical, political, and of convenience. This division is illustrated in a number of ways. The sovereign, for example, holds a unique Canadian title and, when she and other members of the royal family are acting in public specifically as representatives of Canada, they use, where possible, Canadian symbols, including the country's national flag, unique royal symbols, armed forces uniforms, and the like, as well as Canadian Forces aircraft or other Canadian-owned vehicles for travel, once in Canadian airspace, or arrived at Canadian event taking place abroad. The Canadian Secretary to the Queen, officers of the Royal Canadian Mounted Police, and other Canadian officials will take over from whichever of their other realms counterparts were previously escorting the Queen or other member of the royal family. The sovereign similarly only draws from Canadian funds for support in the performance of her duties when in Canada or acting as Queen of Canada. Abroad, Canadians do not pay any money to the Queen or any other member of the royal family, either towards personal income or to support royal residences outside of Canada, succession and regency as in the other Commonwealth realms. The current heir apparent to the throne is Prince Charles, with the next three in the line of succession being the Prince's eldest son, Prince William, followed by William's two children, Prince George and Princess Charlotte. Upon a demise of the crown, the late sovereign's heir immediately and automatically succeeds, without any need for confirmation or further ceremony. Hence arises the phrase, "The king is dead. Long live the king." Quote, "It is customary for the accession of the new monarch to be publicly proclaimed by the Governor-General on behalf of the Privy Council, which meets at Rideau Hall after the accession. Following an appropriate period of mourning, the monarch is also crowned in the United Kingdom in an ancient ritual, but one not necessarily for a sovereign to reign. By the Interpretation Act of 2005, no incumbent appointee of the Crown is affected by the death of the monarch, nor are they required to take the oath of allegiance again, and all references in legislation to previous monarchs, whether in the masculine or feminine, continue to mean the reigning sovereign of Canada, regardless of his or her gender. This is because, in common law, the crown never dies. After an individual ascends the throne, he or she usually continues to reign until death. The relationship between the Commonwealth realms is such that any change to the rules of succession to the respective crowns requires the unanimous consent of all the realms. Succession is governed by statutes, such as the Bill of Rights 1689, the Act of Settlement 1701, and the Acts of Union 1707. In 1936, King Edward VIII abdicated and any possible future descendants of his were excluded from the line of succession. The Statute of Westminster 1931 disallowed the UK from legislating for Canada, including in relation to succession. Order in Council p.c. 3144 was issued, expressing the Cabinet's request and consent for His Majesty's Declaration of Abdication Act 1936 to become part of the laws of Canada, and the Succession to the Throne Act 1937 gave parliamentary ratification to that action, together bringing the Act of Settlement and Royal Marriages Act 1772 into Canadian law. The latter was deemed by the Cabinet in 1947 to be part of Canadian law, as is the Bill of Rights 1689, according to the Supreme Court of Canada. The Department of External Affairs included all succession-related laws in its list of acts within Canadian law. In 2011, Canada committed to the Perth Agreement with the other Commonwealth realms, which proposed changes to the rules governing succession to remove male preference and removal of disqualification arising from marriage to a Roman Catholic. As a result of the Perth Agreement, the Canadian Parliament passed the Canadian Succession to the Throne Act, 2013, which gave the country's assent to the succession to the Crown Bill 2013, at that time proceeding in the Parliament of the United Kingdom. Certain aspects of the succession rules have been challenged in the courts. For example, under the provisions of the Bill of Rights 1689 and the Act of Settlement 1701, Catholics are barred from succeeding to the throne. However, the prohibition has been upheld twice by Canadian courts, once in 2003 and again in 2014. Canada has no laws allowing for a regency. Should the sovereign be a minor or debilitated, none have been passed by the Canadian Parliament, and it was made clear by successive cabinets since 1937 that the United Kingdom's Regency Act had no applicability to Canada, as the Canadian Cabinet had not requested otherwise when the Act was passed that year, and again in 1943 and 1953. As the 1947 letters patent issued by King George VI permit the Governor-General of Canada to exercise almost all of the monarch's powers in respect of Canada, the Viceroy is expected to continue to act as the personal representative of the monarch, and not any regent, even if the monarch is a child or incapacitated. Federal and provincial aspects. Canada's monarchy was established at Confederation, when its executive government and authority were declared to continue and be vested in the Queen. The Canadian monarchy is a federal one in which the Crown is unitary throughout all jurisdictions in the country, the sovereignty of the different administrations being passed on through the overreaching Crown itself as a part of the executive, legislative, and judicial operations in each of the federal and provincial spheres, and the headship of state being a part of all equally. The Crown thus links the various governments into a federal state, though it is simultaneously also divided into 11 legal jurisdictions, or 11 crowns, 1 federal and 10 provincial, with the monarch taking on a distinct legal persona in each. As such, the Constitution instructs that any change to the position of the monarch or his or her representatives in Canada requires the consent of the Senate, the House of Commons, and the legislative assemblies of all the provinces. The Governor-General is appointed by the Queen on the advice of her federal Prime Minister, and the Lieutenant Governors are appointed by the Governor-General on the advice of the federal Prime Minister. The Commissioners of Canada's territories are appointed by the federal Governor-in-Council, at the recommendation of the Minister of Indian Affairs and Northern Development, but, as the territories are not sovereign entities, the commissioners are not personal representatives of the sovereign. The Advisory Committee on Viceregal Appointments, which may seek input from the relevant Premier and provincial or territorial community, proposes candidates for appointment as Governor-General, Lieutenant Governor, and Commissioner. Personification of the Canadian state. As the living embodiment of the Crown, the sovereign is regarded as the personification of the Canadian state, and, as such, must, along with his or her viceregal representatives, remain strictly neutral in political terms. The body of the reigning sovereign thus holds two distinct personas in constant coexistence, that of a natural-born human being and that of the state as accorded to him or her through law. The Crown and the monarch are conceptually divisible but legally indivisible. The office cannot exist without the office holder, so, even in private, the monarch is always on duty. The terms the state, the Crown in right of Canada, Her Majesty the Queen in right of Canada, and similar are all synonymous, and the monarch's legal personality is sometimes referred to simply as Canada. As such, the King or Queen of Canada is the employer of all government officials and staff, the guardian of foster children, patron, as well as the owner of all state lands, buildings and equipment, state-owned companies, and the copyright for all government publications. This is all in his or her position as sovereign, and not as an individual. All such property is held by the Crown in perpetuity and cannot be sold by the sovereign without the proper advice and consent of his or her ministers. The monarch is at the apex of the Canadian order of precedence and, as the embodiment of the state, is also the locus of oaths of allegiance, required of many of the aforementioned employees of the Crown, as well as by new citizens, as by the oath of citizenship. Allegiance is given in reciprocation to the sovereign's coronation oath, wherein he or she promises to govern the peoples of Canada, according to the respective laws and customs. Head of state. Though it has been argued that the term head of state is a republic and one inapplicable in a constitutional monarchy such as Canada, where the monarch is the embodiment of the state and thus cannot be head of it, the sovereign is regarded by official government sources, judges, constitutional scholars, and pollsters as the head of state, while the governor-general and lieutenant governors are all only representatives of, and thus equally subordinate to, that figure. Some governors-general, the staff, government publications, and constitutional scholars like Edward McWhinney and C.E.S. Franks have, however, referred to the position of Governor-General as that of Canada's head of state, though sometimes qualifying the assertion with de facto or effective. Franks has hence recommended that the Governor-General be named officially as the head of state. Still others view the role of head of state as being shared by both the sovereign and her viceroys. Since 1927, governors-general have been received on state visits abroad as though they were heads of state. Officials at Rideau Hall have attempted to use the letters patent of 1947 as justification for describing the governor-general as head of state. However, the document makes no such distinction, nor does it effect an abdication of the sovereign's powers in favor of the viceroy, as it only allows the governor-general to act on the Queen's behalf. Michael D. Jackson, a former protocol officer for Saskatchewan, argued that Rideau Hall had been attempting to recast the Governor-General as head of state since the 1970s, and doing so preempted both the Queen and all of the lieutenant governors. This caused not only precedence wars at provincial events and Governor-General Adrienne Clarkson to accord herself precedence before the Queen at a national occasion, but also constitutional issues by unbalancing the federalist symmetry. This has been regarded as both a natural evolution and as a dishonest effort to alter the Constitution without public scrutiny. In a poll conducted by Ipsos Reid following the first prorogation of the 40th Parliament on the 4th of December 2008, it was found that 42% of the sample group thought the Prime Minister was head of state, while 33% felt it was the Governor-General. Only 24% named the Queen as head of state, a number up from 2002, when the results of an EKOS Research Associate survey showed only 5% of those polled knew the Queen was head of state. Federal constitutional role. Canada's constitution is based on the Westminster parliamentary model, wherein the role of the Queen is both legal and practical, but not political. The sovereign is vested with all the powers of state, collectively known as the royal prerogative, leading the populace to be considered subjects of the Crown. However, as the sovereign's power stems from the people and the monarch is a constitutional one, he or she does not rule alone, as in an absolute monarchy. Instead, the Crown is regarded as a corporation sole, with the monarch being the center of a construct in which the power of the whole is shared by multiple institutions of government, the executive, legislative, and judicial, acting under the sovereign's authority, which is entrusted for exercise by the politicians and the judges and justices of the peace. The monarchy has thus been described as the underlying principle of Canada's Canada's institutional unity and the monarch as a guardian of constitutional freedoms, whose job is to ensure that the political process remains intact and is allowed to function. The Great Seal of Canada signifies the power and authority of the Crown flowing from the sovereign to parliamentary government, and is applied to state documents such as royal proclamations and letters patent commissioning cabinet ministers, senators, judges, and other senior government officials. The lending of royal authority to the cabinet is illustrated by the Great Seal being entrusted by the Governor-General, the official keeper of the seal, to the Minister of Innovation, Science, and Economic Development, who is ex officio the Registrar-General of Canada. Upon a change of government, the seal is temporarily returned to the Governor-General and then lent to the next incoming Registrar-General. The Crown is the pinnacle of the Canadian forces, with the Constitution placing the monarch in the position of Commander-in-Chief of the entire force, though the Governor-General carries out the duties attached to the position and also bears the title of Commander-in-Chief in and over Canada. Further included in Canada's constitution of the various treaties between the Crown and Canadian First Nations, Inuit, and Inuit peoples, who view these documents as agreements directly and only between themselves and the reigning monarch, illustrating the relationship between sovereign and Aboriginals. Executive. The Government of Canada, formerly termed Her Majesty's Government, is defined by the Constitution as the Queen acting on the advice of her Privy Council, what is technically known as the Queen in Council, or sometimes the Governor in Council, referring to the Governor-General as the Queen's stand-in. One of the main duties of the Crown is to ensure that a democratically elected government is always in place, which means appointing a Prime Minister to thereafter head the Cabinet, a committee of the Privy Council charged with advising the Crown on the exercise of the royal prerogative. The Queen is informed by her Viceroy of the swearing-in and resignation of Prime Ministers and other members of the Ministry, remains fully briefed through regular communications from her Canadian ministers, and holds audience with them whenever possible. By convention, the content of these communications and meetings remains confidential so as to protect the impartiality of the monarch and her representative. The appropriateness and viability of this tradition in an age of social media has been questioned. In the construct of constitutional monarchy and responsible government, the ministerial advice standard is typically binding, meaning the monarch reigns but does not rule, the cabinet ruling in trust for the monarch. This has been the case in Canada since the Treaty of Paris ended the reign of the territory's last absolute monarch, King Louis XV. However, the royal prerogative belongs to the Crown and not to any of the ministers, and the royal and viceroyal figures may unilaterally use these powers in exceptional constitutional crisis situations, thereby allowing the monarch to make sure that the government conducts itself in compliance with the Constitution. There are also a few duties which must be specifically performed by, or bills that require assent by, the Queen. The royal prerogative also extends to foreign affairs, including the ratification of treaties, alliances, international agreements, and declarations of war, the accreditation of Canadian High Commissioners and ambassadors and receipt of similar diplomats from foreign states, and the issuance of Canadian passports, which remain the sovereign's property. It also includes the creation of dynastic and national honours, though only the latter are established on official ministerial advice. Parliament. All laws in Canada of the monarchs and the sovereign is one of the three components of Parliament, are formally called the Queen in Parliament, but the monarch and viceroy do not participate in the legislative process save for the granting of royal assent, which is necessary for a bill to be enacted as law. Either figure or a delegate may perform this task, and the Constitution allows the viceroy the option of deferring assent to the sovereign. The Governor-General is further responsible for summoning the House of Commons, while either the viceroy or monarch can prorogue prorogue and dissolve the legislature, after which the Governor-General usually calls for a general election. The new parliamentary session is marked by either the monarch Governor-General or some other representative reading the speech from the throne. Members of Parliament must recite the oath of allegiance before they may take the seat. Further, the official opposition is traditionally dubbed as Her Majesty's Loyal Opposition, illustrating that, while its members are opposed to the incumbent government, they remain loyal to the sovereign. The monarch does not have the prerogative to impose and collect new taxes without the authorization of an Act of Parliament. The consent of the Crown must, however, be obtained before either of the Houses of Parliament may even debate a bill affecting the sovereign's prerogatives or interests, and no Act of Parliament binds the Queen or her rights unless the Act states that it does. Courts. The sovereign is responsible for rendering justice for all her subjects and is thus traditionally deemed the fount of justice. Her position in the Canadian courts, formerly dubbed the Queen on the Bench, though the monarch does not personally rule in judicial cases. This function of the royal prerogative instead performed in trust and in the Queen's name by officers of Her Majesty's Court. Common law holds the notion that the sovereign can do no wrong. The monarch cannot be prosecuted in her own courts, judged by herself for criminal offences. Civil lawsuits against the Crown in its public capacity are permitted, but lawsuits against the monarch personally are not cognizable. In international cases, as a sovereign and under established principles of international law, the Queen of Canada is not subject to suit in foreign courts without her express consent. The monarch, and by extension the Governor-General, also grants immunity from prosecution, exercises the royal prerogative of mercy, and may pardon offences against the Crown, either before, during, or after a trial. An image of the Queen and/or the arms of Her Majesty in Right of Canada is always displayed in Canadian federal courtrooms. Itinerant judges will display an image of the Queen and the Canadian flag when holding a session away from established courtrooms. Such situations occur in parts of Canada where the stakeholders in a given court case are too geographically isolated to be able to travel for regular proceedings.